Now let me introduce our special guest this morning, Mr. Benjamin Zelenko. Mr. Zelenko is the former General Counsel to the Committee of the Judiciary in the U.S. House of Representatives. He advised the committee during hearings, markup, and House floor debate on the landmark Civil Rights Act of 1964, the Voting Rights Act of 1965, and other civil rights legislation during the 1960s. In addition, during that time, the House Judiciary Committee considered and approved 2 constitutional amendments. One dealt with presidential succession, that would be the 25th Amendment, and the other, which granted the 18-year-old the right to vote, our 26th Amendment. Today, Mr. Zelenko is senior counsel with the international law firm Lewis Bach. We are really privileged, let me tell you, to have somebody this fascinating in our midst with a legacy like that one. And so welcome, Mr. Zelenko. We look forward to hearing you.
Good morning.
Good morning.
Thanks to the Embry Family Foundation and Race Forward, I really appreciate the opportunity to talk about something that I've spent a lot of my professional life involved with. I want to talk about 3 things, past, present, and future, future with a question mark. The past I can talk about because I worked on those bills, and I want to convey to you some of the strategies, some of the interpersonal relations in getting legislation of that kind through Congress 50 years ago. Dorr said that in order to make that kind of change in society, you needed the cooperation of all 3 branches of government: federal judiciary, federal Congress, and the executive branch. And we had the cooperation of all 3 branches. And those were vast changes in the culture of America. It was the first comprehensive civil rights legislation passed since emancipation, 100 years. I won't recite the violence, the killing, the lynching, the intimidation, the coercion that went on throughout that period. But it led up, it boiled over by 1963. One of the important points, of course, was in '54 was the Brown decision. But there were killings after that. There were demonstrations after that. There was Rosa Parks and the boycott in Birmingham. There was a Connor with the water cannons and the police dogs in Birmingham. By the time Kennedy got elected, Eisenhower had seen to it that 2 civil rights bills passed, the 57 Act and the 60 Act, and they were nibbling at the edges. They set up the Civil Rights Division in the Department of Justice. They established the Civil Rights Commission, and they made efforts to get voting open, get access to voting and registration to all, irrespective of color and race. But they weren't successful because they stayed with the litigation process. And any lawyer knows that litigation can always be drawn out. And if you're in a situation where the community is hostile, you can bet on it being drawn out. So as cases would succeed, just as the judgment would come down, the rules would change. So you'd have to have another case. And in order to have another case, you'd have to have voting records. And voting records would be destroyed. And then even if you had the voting records and you had a case that succeeded, they would change data registration, requirements to register. They would intimidate people. I remember John Doerr had a case where he succeeded. It was a farmer, and they wouldn't buy his crop because he went down to register. He brought a suit, he got an order. They would buy his crop, but they wouldn't give him access to the gin, so he couldn't use the cotton gin. It was worthless. It was that kind of, and of course people were intimidated, houses were burned, churches were burned, all the rest. I joined the committee in '61, in '63 was the first major legislation that I worked on. And it was introduced by Kennedy on June 11th, the very day that George Wallace stood in the courthouse door in the University of Alabama to block the entrance of 2 students who were there by court order. Now, you may not remember, because I've got all the gray hair, but Katzenbach, the Deputy Attorney General, Nick Katzenbach, went down there with a National Guard that were federalized and confronted Wallace in the door, and the students were admitted. Wallace did back down. There was no violence, and it was televised. You know, television was very new in those days. The first campaign, a debate campaign, was Nixon and Kennedy, and that was in 1960. So now we're in 1963, televised, the governor of Alabama saying you can't come in. The Deputy Attorney General of the United States saying I have a court order. And then the governor of Alabama standing aside. Well, on that day, June 11, that night, Kennedy decided he would give a speech to the country. I want to just read a few lines from the speech because I think they are pertinent today as they were in '63. Quote, "We are confronted primarily with a moral issue. It is old as the scriptures and it is clear as the American Constitution. The heart of the question is whether all Americans are to be afforded equal rights and equal opportunities, whether we're going to treat our fellow Americans as we want to be treated." And he went on, "It ought to be possible for American students of any color to attend any public institution they select without having to be backed up by troops. It ought to be possible for American consumers of any color to receive equal service in places of public accommodation, such as hotels and restaurants and theaters, retail stores, without being forced to resort to a demonstration in the street. And it ought to be possible for American citizens of any color to register and to vote in a free election without interference or fear of reprisal. In short, it ought to be possible for every American to enjoy the privileges of being American without regard to his race or color." End quote. I think those words have equal force today. And as we will see, there has been backsliding from 50 years ago. We've made great strides, but we're not there yet. The bill was introduced shortly following that June 11th speech. It was introduced by my boss in the House, and we had hearings, and we had 22 days of hearings. We heard over 100 witnesses. We had 2,500 pages of testimony. Bob Kennedy was the Attorney General. He testified. And when we finished the hearings in August, there was a march in Washington. That march was, it's fair to say, dreaded by the Kennedy administration. They were fearful, and many members of Congress were too as well, that there would be violence in the city because there had been so much violence in connection with civil rights around the country. And that would torpedo any legislation. So if you ask the president privately, do you want this to occur, the answer would be no. In fact, he secretly mobilized the Guard and federal troops outside of Washington in case there would be trouble. The March on Washington occurred on August 28th. I attended it. I'll never forget it. It was moving and it was inspiring. I guess there were 250,000. I didn't count them, but there were a lot of people there. And it was like a big picnic. It was a wonderful, wonderful day. Martin Luther King's speech, frankly, wasn't the highlight at the time. It has come to be the highlight. It's certainly worthy of being the highlight. What was impressive was the spirit of that day. Anyway, that was the March on Washington. After that, our subcommittee, 7 Democrats and 4 Republicans, sat down to read the bill line by line. In the course of that, there was a horrific bombing of a church in Birmingham. 4 children were killed. 22 were injured. And the Democrats on the committee, who were very pro-civil rights, our chairman was, and they followed the chairman, were emboldened to strengthen the Kennedy bill. And we did. We added an Equal Employment Opportunity Commission. We made the voting provisions apply to state elections as well as federal elections. We applied the public accommodations to all accommodations, whether they were in commerce or not, so long as they were licensed by the state or the city. We broadened that bill. And the effect was to get the Republicans to threaten backing off. They were worried that they couldn't carry the bill in the House if it was that strong. Now, the strategy that Bob Kennedy and the administration had was to get a bill and assure a solid Republican support. You know, this sounds so funny today, where there's no bipartisanship on anything. But in those days, civil rights would never have gone forward without Republican support, because the Democrats had the representation of Dallas, Texas, and all the rest of the South. And they were not supporting civil rights. So we had a schism in the Democratic Party. We didn't have a schism in the Republican Party, except there was concern that they would be left holding the bag, that the bill would be strengthened and wouldn't pass, and they would be seen as the reason for it not passing. And so they enlisted Bob Kennedy, and the Justice Department came to their rescue. Seller, my boss, and our effort to strengthen the bill was seen as torpedoing the chances of passage. And so the Justice Department worked with the Republicans and came up with a hybrid that could be acceptable to some Democrats as well as the Republicans. And that's what ultimately got passed. But it was a tough time there for a while. There was concern that we would have no civil rights bill. And without going into more detail than you'll want to hear, the day of final committee action, the members were delivered this compromise bill at their homes, at the door of their homes, at 3 or 4 o'clock in the morning. They showed up, and the bill was essentially what they had seen before, but with changes to the subcommittee version. And it had to be read in committee before it could be passed. And there was no authority to work past noon because the House went into session. So the bill had to be read first, because there were Democrats that were arguing it had to be read. There were 55 pages, and you know how you get dry when you read. The counsel was reading the bill, and it was getting dry, and time was going out, and there was about 5 minutes left. He finished reading. There was a minute explanation by the Democrats, minute explanation by the Republican. There was a vote, and as the bells rang, the bill had passed. It was a very exciting time, but it could have been stopped right there. Anyway, we went to the floor. We were on the floor of the House in the longest debate ever in the history of the House up until that time. Excluding Sundays, we were on the floor for 10 days, day sessions and night sessions. My boss was 75 at the time. His counterpart, the Republican ranking member, was in about 70 or 69, and they were on their feet the whole time. And every part of the bill was subject to amendment, and they were able to stop most of the amendments as we went through the bill, except one amendment, which I think is worth mentioning. We had as a Title VII, the Equal Employment Opportunity Commission, which banned discrimination in work, employment, based on race, color, creed, or national origin. And Howard Smith, who was the chairman of the Rules Committee, a segregationist from Virginia, got up and offered an amendment to add sex to those categories. We saw it as an effort to torpedo the bill because it was very controversial at that time. And so Seller, the great libertarian, my boss, who was the manager of the bill, got up and opposed the bill. No, opposed the amendment, I should say. And people were questioning why a segregationist was so interested in equal rights for women on a civil rights bill. Well, that sex amendment carried. Not only carried, it strengthened the bill. So much for Howard Smith and the segregationists. Now it goes over to the Senate, and I never understood the Senate. I don't now. They had filibusters, you know, and all the rest. But part of the strategy was not to allow that bill to be considered in a House-Senate conference, where both sides work out and get a compromise. And the reason for that is that the members of the conference committee from the Senate would be ranking Democrats from the Judiciary Committee who included all segregationists. Eastland from Mississippi, Sam Ervin of North Carolina. Love Sam Ervin, but not on civil rights. Strom Thurmond, another great hero of segregation. John McClellan. So the strategy was get the bill out of the House, get it to the Senate, get through the filibuster somehow, and get it passed, but without amendments, so many amendments that the House couldn't accede to them. And so that it could go back to the House without a conference, and the House could agree. And that's what happened. It took a little doing, and you were not interested in the procedural, but there were procedural battles. And it finally came back to the House for passage on July 2nd, 1964. And it passed overwhelmingly. And within 5 hours that day, President Johnson signed the bill. And I was president of the signing, and I'll never forget that. But that's very rare. And everybody wanted a pen. Even people who were on the fence about signing the bill to begin with, they all wanted a pen. Now, in '64, after the bill was signed, there was an election. And Johnson ran against Goldwater. It's fair to say that he crushed Barry Goldwater. He got 61% of the vote. The Democrats in the House picked up 38 seats. They picked up 2 seats in the Senate. It was a victory the likes of which had not been seen, I don't know if ever, but certainly for a long time. Then he gets sworn in on his own right. LBJ gives a speech, and the Republicans give a speech, and nothing is said about civil rights. And then March comes, and Selma, Alabama happens. That was all televised, and the results of that, and of the freedom rides, of the violence to the sit-ins, to the murders of Goodman and Cheney and Schwerner, all these things, all of this violence, all over voting, rights to access. And now the Civil Rights Act of '64 has passed, but voting is still an issue. Johnson goes before a joint session and gives a speech. And I want to quote just a little bit of it because it pertains to the Voting Rights Act. Many of the issues of civil rights are very complex and most difficult, but about this there can and should be no argument. Every American citizen must have an equal right to vote. Every device of which human ingenuity is capable has been used to deny this right. The Negro citizen may go to register only to be told that the day is wrong, or the hour is late, or the official in charge is absent. And if he persists, and if he manages to present himself to the registrar, he may be disqualified because he did not spell out his middle name, or because he abbreviated a word. And if he manages to fill out an application, he is given a test. The registrar is the sole judge of whether he passes this test. He may be asked to recite the entire Constitution, or explain the most complex provisions of state law. And even a college degree cannot be used to prove that he can read or write. For the fact is that the only way to pass these barriers is to show a white skin. And he said, all of us must overcome the crippling legacy of bigotry and injustice, and we shall overcome. And the Voting Rights Act came up. And it abolished literacy tests, established statutory procedures to protect and secure the right to vote, and together, those two statutes, the 64 and the 65 Acts, established the structure, legal structure, that support modern-day racial justice. And we've made significant progress in combating racial discrimination over the past 50 years. Safeguards in many areas, however, remain neglected. And recent rulings of the Supreme Court restricting affirmative action and voting rights have not helped the nation deal with racial problems. In a recent case, Shelby County, Alabama, versus Holder, the Supreme Court struck down a key provision of the Voting Rights Act. And based on the view, quote, and this is Justice Roberts, things have changed dramatically, end quote. Someone liked that argument to the fact that it's like having an umbrella in a rainstorm and being dry and then closing the umbrella. You know, we're better off because of the protections of the Voting Rights Act, not in spite of them. Now, in a dissent, Justice Ginsburg, who has been dissenting a lot lately, said this about that opinion, which struck out a key provision of the Voting Rights Act. The majority appears to believe that the Voting Rights Act's success in eliminating specific devices means that pre-clearance is no longer needed. In truth, the evolution of voting discrimination into more subtle, second-generation barriers is powerful evidence that a remedy as effective as pre-clearance remains vital to protect minority voting rights and prevent backsliding. I don't want to get too technical, but pre-clearance means that if you're a covered jurisdiction, and this state is one of the covered jurisdictions, South Carolina, Alabama, Georgia, even a county in New York at one point was covered because less than 50% of the eligible population voted or was registered to vote, and because there was evidence of discrimination in the recent past. Right after this decision, where the court struck out the formula for which parts of the country would be covered, a number of states instituted changes in their voting procedures. North Carolina, which barred same-day registration, Ohio, which cut back on early voting, and Texas, and we're in Texas today, instituted the most stringent voter ID law in the country. Now, it's a complicated case, and I don't want to get too many details, but there was a district judge, federal district judge in Corpus Christi, who held a 9-day trial, wrote a 147-page opinion, and found that the new voter ID law in Texas was unconstitutional, was discriminatory, that would bar or affect minority voters far more than disproportionately, and issued an injunction. The Fifth Circuit, I ought to mention a little bit, among the photo IDs that are unacceptable under Texas law, a photo ID from an in-state 4-year college, an ID from a federally recognized Indian tribe, an ID issued by the Department of Veteran Affairs. Now, it's complicated because Texas law does allow you to get a certificate for voting, but you have to show a birth certificate, a certified birth certificate. can't get a certificate, and that may be $27 or $30, whatever. There's an option, there's a cheaper ID, but they haven't publicized that. And so the judge, and Ginsburg in her dissent, said that this law could disenfranchise, or at least affect, upwards of 600,000 voters in Texas. Now, we can't tell whether it did or not because the turnout in this last election was so low. Nationally, it's estimated that it was the lowest turnout since 1942. But the district court said the impact of the stringent requirements for only certain types of photo ID would fall disproportionately on blacks and Latinos and prevent hundreds of thousands from voting. And it held that it was an unconstitutional poll tax. And the Federal Appeals Court, Fifth Circuit, stopped the injunction. Parties went up to the Supreme Court and asked that the stay be dissolved, and the Supreme Court allowed the stay to exist. So there's been no decision on the constitutionality of the ID law yet, but it applied in this last election. Racial discrimination in voting access, in education, employment, and housing still persists. Systemic shortcomings in law enforcement, police-community relations, the operations of the criminal justice system must be addressed. While institutional discrimination may have been curtailed, de facto discrimination still exists. Ghettos of blacks in cities and towns, north and south, still flourish. Public school education, employment, and housing opportunities are severely impacted. Economic deprivation and maltreatment by law enforcement and struggles with the justice system persist. After 50 years, one may reasonably wonder how far we really have come. Clearly, much more needs to be done. A national conference on race such as this one, sponsored by Race Forward in Dallas, is the appropriate place and the appropriate time to examine the issues and determine the most effective actions to advance racial justice. We need political leadership, we need grassroots activism, and we need the effective cooperation of the federal judiciary. Nevertheless, I'm confident that men and women of goodwill will persevere and help overcome the scourge of discrimination. Thank you very much.